Well, that turns out to still be a disputed question 29 years after the decision. I think the better view is that in order to be generally applicable, a law has to apply to everybody who's doing similar things that cause the same alleged harms. In Churchill-Lukumi versus Hialeah, which was the animal sacrifice case in 1993, the Supreme Court said, look, people kill animals for all kinds of secular reasons, for food and for pest control. And there's hunting, there's fishing, there's serious reasons and not so serious reasons. None of those are regulated. The only thing you regulated was religious sacrifice of animals. Well, that's a pretty easy case. That's obviously not generally applicable. Most of the cases are more complicated than that. Justice Alito, when he was on the Court of Appeals, had a case from Newark. Newark police officers were required to be clean-shaven. But there was an exception if you had a medical problem that made it difficult to shave. There was no exception for Muslim officers who were religiously obligated to grow a beard. So there's only one exception, and it applies only to a small percentage of the force. There were lots of other reasons why people might want to grow beards that weren't protected. If you want to grow a beard for fashion or to cover a scar on your cheek or because your wife really likes beards or whatever, you still had to be clean-shaven. Right, so you had a rule that applied to most police officers, but it didn't apply to all police officers. And what Judge Alito said was, look, the city has made a judgment here that medical needs are more important than religious needs. And that's what the requirement of general applicability is really about. The implication of that is, if you have any kind of secular exception that undermines the government's interest in regulating religion, then you have to have a religious exception as well. Now, there's another line of cases, a smaller number, that basically say generally applicable is an odd way of talking about bad motive. And you have to show the government was actually hostile to this religion and trying to stamp it out. Those were the facts of the animal sacrifice case. I think that's just not what the word means, and it's not how the Supreme Court explained it in its opinion.